Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're right in the middle of the 23 legislative session, and we've been focusing an awful lot on banning of assault weapons, pre-purchasing licensing, getting rid of state preemption. Seems to be the three big hot button topics that a lot of us are spending a lot of attention on. There are numerous other gun control measures out there, and we've done this video right here, which kind of gives you a full rundown of how many there really are. There's a bill out there that has really not gotten any attention by anyone, including us here in Washington Gun Law, but I think it's one that we all ought to slow down and pay careful attention to, because I think it could have some unintended consequences. So today, let's spend a few minutes and tell you about the bill that could make you a felon. Okay, before we get going down the road we're going down, proud to announce that this video is being brought to you by Federal Way Discount Guns. That's right, Federal Way Discount Guns has been serving South King County right in this location for over 30 years now. Now, in addition to the notoriety that they have recently gotten and the fundraising that is going on to help them out, go ahead and click this link down below or scan this QR code. Hey, they have a full-service operation right now where they will help you with your E-Form 1. Why would you need help with an E-Form 1? I don't know. Maybe some of you went to bed a couple of weeks ago, the proud owner of an AR pistol, only to wake up one morning to find out, no, you actually own a federally regulated short barrel rifle. Now you have 120 days to fill out your E-Form 1. Don't know what to do, don't know where to start, don't know what the hell's going on? Well, visit Mo or any of his great employees down there at Federal Way Discount Guns, and they will run you through the entire process. It is a one-stop shop. We'll get everything done for your Form 1 registration. And listen, if you use the promo code Washington Gun Law, that's Washington Gun Law, all one word, you will get 15% off. So for more information, visit them at federalwaydiscountguns.com. Okay, so the topic we're talking about today is House Bill 1562, sponsored by a litany of Democrats in the Washington State House of Representatives. Now, this bill is designed to help stem domestic violence and violence against women, and the crux of this bill is that by taking a look at past performance, people who have previously been in trouble, we can better determine who is likely to use violence in the future. And there is a little bit of data to actually back that up. So what this really focuses on is Washington's restoration rights, okay? But there's some other consequences in here, and you need to be aware of that. Now, most of you are lawful and responsible gun owners, so you don't have to worry about restoring your Second Amendment rights. If, however, you have a friend, a family member who does, we have done a series of videos about how to restore your rights. And I will tell you that if House Bill 1562 becomes actual law, we're going to have to reshoot a lot of those videos because the time periods under which and the things that you're disqualified for are going to significantly change. Now, many in the lawful and responsible gun owning community do not have as much problem with firearm restoration laws as they do with other types of legislation. And what we have always said here at Washington Gun Law is that for those that get convicted of felonies and they lose their Second Amendment rights, that is exactly how the law is intended to work. However, we have restoration laws so that when you paid your debt to society and proven to society that that was an isolated incident, you have the right to absolutely, positively restore those rights in as they were before. And that, too, is how the law works, and we support that. But here's the thing. RCW 9.41.040, it's a huge, gigantic word salad statute that looks like this, and it has all the procedural mechanisms in there on how to restore rights. But at the very top of the statute, and this is what I want to talk to you guys about, at the very top of the statute, it lists what it is to be in unlawful possession of a firearm. Because in Washington State, any state for that matter, if you've previously been convicted of felonies, have not had your firearm rights restored by a court of law, and then in possession of a firearm, that too constitutes a felony. It's violation of the Uniform Firearms Act. When I used to prosecute back in the day, we called them VUFAs. And depending on what the felony is, you can be charged either with a first-degree felony possession of a firearm or a second-degree felony of a possession of a firearm. Without geeking out too far and going too far into those woods, essentially, if you've been convicted of some very serious offense and now you're in possession of a firearm, that's a VUFA 1. And if it's a less serious yet felony or domestic violence misdemeanors or things like that, then they're going to be charged with unlawful possession of a firearm in a second degree. Now, this is how the current statute reads. A person, whether an adult or juvenile, is guilty of the crime of unlawful possession of a firearm in the first degree if the person owns, has in his or her possession, or has in his or her control any firearm after having previously been convicted or found not guilty by reason of insanity in this state or elsewhere of any serious offense as defined in this chapter. And then second degree felony possession is basically word for word the same, except you've been convicted of some other disqualifying offense which is not defined as a serious offense, okay? So that is how we define people who are in unlawful possession of a firearm right now. However, if House Bill 1562 were to be passed, the new law would read as follows. A person, whether adult or juvenile, is guilty of the crime of unlawful possession of a firearm in the first degree if the person owns, accesses, has in their custody, control, or possession, receives, purchases, or attempts to receive or purchase any firearm after having previously been convicted or found not guilty by reason of insanity in this state or elsewhere of any serious offense. Okay, and then the amendments to felony firearm possession in the second degree is the same thing, so it's this attempt to purchase. Now, here's the thing that we all need to be aware of, and many of you lawful and responsible gun owners probably don't know this, so you may have to take my word for it. But we're going to talk about one of the most common things that we run into here for people who believe they have restored their rights, and this is how the story goes. Let's talk about a guy named Joe. Joe in the 1980s, when he was working as an investment banker, was living a pretty fast and wild lifestyle. He was dressing like he was in Miami Vice all the time and doing a ton of blow. Unfortunately, one night back in 1984, Joe got pulled over for a DUI and search incident to arrest. They did find that 8-ball of coke in his car. Joe went down on a felony drug possession. Now, it wasn't the end of the world. He only did a couple of days in jail, did some drug treatment, and all was good. Fast forward to the early 2000s, Joe is an entirely different guy now. He has a family, he has a very successful career, and all of the nonsense has stopped. Joe also decides at that point that he needs to restore his firearm rights. Joe goes and hires an attorney, you know, one of those $500 attorneys you can find online, who says, absolutely, I can get your rights restored. He goes to court and gets an order from the court that originally took Joe's Second Amendment rights saying, hey, you are in fact restored. Hallelujah. Now, Joe doesn't really think he needs a firearm at this time, but it is nice to know he has his rights back. What the attorney doesn't do, however, is he doesn't do the work necessary to vacate the conviction, or in some jurisdictions to expunge or seal the conviction such that it will change on Joe's federal background check as well. So while the state background check has been taken care of, the federal background check has not. Now, Joe isn't any wiser because, hey, he's the layperson who hired the lawyer. The lawyer who promised to get Joe his rights restored on the state level has technically done their job. But what they haven't done is clear Joe on the federal level. And as I explain to people all the time, if you have your gun rights in the state of Washington restored, but you can't ever buy a gun, do you really have your gun rights restored? Well, now fast forward to the summer of 2020. During the summer of love, Joe's city is burning. His local police is being defunded while the state government is trying to defund him. And Joe decides, you know, I think I might need to go get a firearm. So Joe goes and, like anyone else, he fills out a Form 4473. Now, he's got an order of restoration from 20 years ago, so all should be good. Well, the problem is when Joe does fill out his 4473, he gets a denial. That's right. His actual background check is denied. Why is that? Well, that felony conviction is still showing on his next background check on the federal level, and Joe is being denied. Now, do we believe for 1 second that Joe has done anything illegal here? Do we believe for 1 second that Joe is up to any type of nefarious act, that Joe is acting in a felonious way, that obviously Joe is a bad guy trying to get a gun for bad purposes? Absolutely not. And yet, this exact scenario happens every day. You don't believe me? Talk to any FFL. And I can assure you, we get multiple calls here at Washington Gun Law every week about this. And lately we've been getting calls from people who have been approved for their last 15 firearm purchases, and suddenly now they're being denied again. And when we look it up, we find out, oh, it's some felony from back in Maryland in 1978 that's still haunting them, okay? This is a possibility. Now, I think there's a big difference between our hypothetical Joe and the person who knows he's a felon, just got out of prison a year ago, and goes and tries to buy a firearm. There is a significant difference. Unfortunately, when we look at the language of what House Bill 1562 wants to do, Joe and the guy who just got out of prison are going to be treated the same way under the law. And knowing how many people in good faith attempt to purchase firearms only to find out that due to some technical difficulty somewhere else, some paperwork snafu, or sometimes some sloppy work on a previous lawyer, they get denied. Individuals like that should not be facing a Class B felony. But let us not forget that a violation of the Uniform Firearm Act, a felony possession of a firearm in the first degree in Washington State is a Class B felony, and a felony possession of a firearm in the second degree in Washington State is still a Class C felony. Listen, I think there are some parts of 1562 that might actually address some parts of our problem. But the big concern is that this is written by people who don't understand how the firearm industry runs. Listen, you may have more questions about House Bill 1562 or any other piece of legislation kicking around in Olympia right now. If you do, remember, you can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, in the meantime, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.